In real property, an action to enforce a restrictive covenant, that is, a contractual right requiring a person to do something or not do something on land, is equitable in nature. Consequently, a plaintiff may seek injunctive relief as an equitable remedy for breach of a restrictive covenant. In Lord and Taylor LLC versus White Flint LP, the Fourth Circuit considered whether a trial court could deny injunctive relief if the relief would require continued judicial supervision. In 1975, White Flint, a real estate developer, planned to build a shopping mall on land it owned in Montgomery County, Maryland. Lord and Taylor and Bloomindale's agreed to lease land immediately adjacent to the mall as anchor store spaces. In exchange, White Flint agreed to construct and maintain a first-class, high-fashion regional shopping center. The parties then entered into a detailed reciprocal easement agreement, or REA. Under the REA, White Flint was required to continue operating the mall as a first-class, high-fashion shopping center through 2042, with a renewal option to 2057. However, over time, mall business declined. In 2012, Bloomingdale's opted not to renew its lease, and eventually the mall became vacant, leaving only Lord and Taylor's still open. Meanwhile, the county planned to develop the area into a mixed-use urban center. As part of that project, White Flint planned to revamp the mall site into a mixed-use development center, with apartment units and high-rise office buildings. Based on the plan, the mall would be demolished, but the Lord and Taylor store would remain. Ultimately, the county approved White Flint's plan. Subsequently, Lord and Taylor sued White Flint in federal district court, seeking a declaratory judgment that the REA precluded White Flint from redeveloping the site. Further, it requested a permanent injunction prohibiting White Flint from constructing the development center. In response, White Flint moved for partial summary judgment. Specifically, it argued it wouldn't be feasible for the court to enforce an injunction requiring an empty mall to resume operations and maintain its status as a first-class, high-end shopping center for over 40 years. The district court agreed and dismissed the part of the complaint seeking an injunction. Lord and Taylor appealed to the Fourth Circuit.